Hello, I'm Anthony Zaller, and this is the California Employment Law Report. This Friday's 5 is coming to you through a video. We're testing some of our podcasting equipment that we will be rolling out a podcast the next couple of weeks, and thought it'd be a good opportunity to introduce the concept to everybody, and that's going to be coming out, so stay tuned for that. But this Friday's 5, I want to discuss arbitration agreements and 5 things employers should know about arbitration agreements given the huge U.S. Supreme Court's ruling earlier this week in Epic Systems Corp. Versus Lewis. The U.S. Supreme Court upheld the use of arbitration agreements, but what's that mean for employers, and what are arbitration agreements? So the first thing I wanted to discuss in this video is what is an arbitration agreement. So employers can enter into arbitration agreements with employees if they're properly drafted. And the arbitration agreement basically is an agreement with the employee that if there's any disputes between the employee and the employer, they're going to a private arbitrator to have those disputes resolved. It's not going to be resolved in the public court of law or downtown Los Angeles or Superior Court in California. Now, some of the more popular arbitration companies are the American Arbitration Association, AAA, people refer to it as, and JAMS. Those are the 2 big ones, but there's a lot of different companies out there. And basically, these companies hire judges, former judges, retired judges, or lawyers to be a private judge. And the benefit is that it's a more confidential proceeding than in Superior Court, where everything is public. And there's some other benefits I'll get to here in a bit, too. But are they enforceable in California? Yes, if they're properly drafted, and employers have to be careful about how they draft the arbitration agreements to make sure that they meet the requirements so that they're enforceable. So that leads me to the third point. Why would employers want to implement arbitration agreements? What are the benefits for employers? Number of benefits. As I mentioned earlier, one, arbitration is more of a confidential proceeding. It's not totally confidential, but it's more confidential than having your case heard in Superior Court. 2, the process and the time generally can be quicker than in Superior Court and in other courts. The arbitrator is generally more available on scheduling and resolving disputes. It can be resolved quicker. So sometimes the parties can save some resources in attorney's fees because the briefing is a lot quicker and a lot less formal than in court. So those are some of the benefits that come along, but there are some drawbacks with arbitration as well. One, the major drawback for employers is that employers have to pay 100% of the arbitrator's fees. Now, a 4 to 5 day arbitration can easily cost $30,000, maybe $40,000. But there are some cost savings, as I discussed earlier, that come into play to offset that amount, and then employers just have to make a decision if they want to pay that to have the other benefits that come along with arbitration. Now, what's the major benefit for employers? And it leads me to my 4th point, is class action waivers, and are they enforceable in arbitration agreements? And the U.S. Supreme Court this week held in the Epic case that class action waivers are enforceable in the employment context, and this is the huge benefit for employers. So basically, employers are in the arbitration agreements can tell employees if they have any disputes, those disputes have to be brought on an individual basis through arbitration. They can't bring it as a class action. Now, in California, there's still the Private Attorney General's Act claims, referred to as PAGA. Employees can't waive their right to PAGA, so those can still exist and be brought on a representative claim. Those aren't necessarily like class actions, but they're sort of like class actions. It's a unique aspect of the law in California. So employers have to understand that the PAGA claim could be out there, but there's some benefits of just defending a PAGA claim as opposed to a full-on class action. So those are some considerations about whether a class action waiver is good or not for employers. Now, it leads me to my 5th point. Should every employer implement an arbitration agreement? I would say not necessarily so. Something employers should consider, but they should go over the pros and cons and the costs associated with arbitration, And especially for smaller employers that don't have the class action liability, I don't know if it's necessarily something that's right for smaller employers all the time, but it might be something if the employer really values the confidentiality and quickness of the arbitration proceedings. So that does it for this Friday's 5. I hope you're liking the new content we're putting out this summer and the new videos on the YouTube channel. Please subscribe to the channel. It really helps the channel. If you have any questions, please comment below. And you can also reach out to the different social media platforms we're on. All the links are below as well. And please stay tuned for the podcast coming out. We have some great interviews lined up. They'll be coming out later this summer. Thanks. Have a good weekend.